My name is Nathaniel Sperger. I'm with the Women's Business Center. We do a lot of things here at the Business Center, but the main focus and the best way to interact with us is through one-on-one counseling. We will talk to you about any stage of your business and any part of your business that you want to talk about, whether it's just the idea, whether you want to know how to set up your business, whether you want to start writing a business plan, or you're trying to figure out how to fund your business. You need to get certified with the government as a minority-owned business. We will talk to you all about that kind of thing and try to guide you towards resources or another organization that can help you or give you the help that we have available for you. We also do this kind of webinars, virtual events with information, with people talking about what they do or their expertise as it relates to business. It's another great way to interact with us and also communicate with other people that are doing similar things to you. So use the chat, put your name in there, tell us what you do, ask questions in the chat, and I'll bring them up to Donna. And without further ado, I'll hand it over to Donna. Donna is a great resource. We have had her on our conference before, and she's done a lot of good stuff with the Women's Business Center previously, and we're very happy to have her here today talking about legal issues for startups. So I'll go ahead and hand it to you, Donna, and I hope everybody enjoys what we have today. Thank you so much.
Welcome. Thank you, Nathaniel. Welcome, everybody. This is going to be a broad overview of issues that you should be aware of. And I'll go into some detail on some things, but it's really what we call a survey course so that you'll be able to see what you need to think about and food for thought, make sure you're on the right track. You haven't missed a basic building block in your business. I have been practicing, the bar just reminded me kindly, for 25 years now. I've exclusively worked with businesses and transactions, and I actually started my own law firm in 2015 so that I could control my costs and therefore control your costs and fees and work with small businesses because that's my passion. If you have questions, I like these to be as interactive as possible. It's hard on Zoom, but ask questions. If you get to something that's just way too detailed for your particular situation and not applicable to a general survey class, I will let you know that, and you can always email me or Nathaniel after, and we can get you more information. But I don't want to bog down the class in anyone's specific situation. I am going to share my screen, hopefully. I'm also going to turn off my camera because I'm working from home and the video is not great. Okay, are we good? Can you guys see that? Nathaniel, can you see the screen? Okay.
Shows up perfectly. Thank you.
Good. Okay. Here is what we're going to talk about today. And honestly, an attorney is a lot like your insurance agent. What we help you do is figure out where things could go wrong and how do we protect you from it. And then everything else is things that, in my experience, go wrong for small business. If you would like a copy of the slides after, I can send a handout with them printed out to Nathaniel, if that's okay with Nathaniel. I forgot to clear that first. Or you can email me. So don't feel like you have to write all this down. You can just listen and take it in, and then you will have, as my children would say, guided notes when you're done. So this is a slide that could be in a business law or MBA class, risk management. If we were standing in person at this point, I would ask you to throw out what kind of risks your business has. And it's all over the place depending on what people are doing and how their brains work. So what as part of your business plan, or even if you don't have a formal business plan, as part of your strategy for starting your business, think about your worst case scenario. I sell food and somebody got sick. I have a space for children that has a bounce house in it and somebody fell and broke their collarbone. I provide services and I got something wrong and I gave them the wrong advice. So think about what happens between you and your customers, but also think about internally what could go wrong. You have extension cords running through your office and a client or employee trips and falls. You don't have computer backups and your computer dies. You have employees. Do you have workers' comp insurance? What happens if they're in their car on a business-related event? They get into a wreck. What if it's their fault? All these things are things that could go wrong for your business. And I just encourage you to think broadly and have plans in place, have backups in place. There's a case where I had a client that back in the day used to have computers that had magnetic tapes. And you would have 2 or 3 sets of magnetic tapes that you switched out every night because that was where your backup went before we had the cloud, before we had disks. And, a different person would take a tape home every night so that there were 3 and they were in different places. And I think there was one that was in the safe. So there was a flood on the upstairs floor. Toilet broke and it came down through the whole building and it flooded everything. So the magnetic tape had accidentally not been taken home that day and the backups got wet. And the one that was in the safe, it was fireproof, but it wasn't waterproof. So it was an unexpected risk that my client thought they had addressed. So my point to you is have backup plans and have multiple places where your backup plans are stored, where your important information is stored. You don't want to be the business that if the computer goes down, everybody's walking around like a zombie because they can't do anything. That happens. Are there any questions? That's really general. That's kind of business consulting advice. It's not legal advice. Are there any questions on that?
The only question I have in the chat right now is about budgeting for legal advice in the beginning setup of a business. Is that like, what is a good, what would you recommend people budget or think about for just starting a business?
All right. It depends a lot on how many owners are in the business, how complicated your business is. Is it regulated? So I hate to say this because it's a stereotypical lawyer answer, but it depends. Mm-hmm. It's true though. If I'm doing a single member LLC or a single member Escort, it's a flat fee of $600. That's on the low side on purpose because, like I said, I've structured my business so that it's really cost efficient so that people can afford to hire me. Some attorneys will post their prices online, but you probably need the entity formation. If we'll get into this a little later, if you have more than one owner, you need some kind of agreement between the owners. Do you need to file a trademark right up front? You do need a form contract almost always. So, it just depends on who you're using and how much they are. It could be $2,000, could be $5,000 or $10,000, just depending on how complicated it is. And, are there 3 partners in there that are highly negotiating the shareholders agreement? So I'd say give it $2,000 for low end. And maybe that's too much, but I like people to be pleasantly surprised and not shocked when the bill comes.
Definitely.
All right. Business name, super important. I want you guys to take away from this class the difference between what's registered with the Secretary of State and what name you use in the public for your selling your goods or services. So this is a company called the Procter & Gamble Company. It's a Delaware corporation. You can see the slide on the bottom, lots of consumer goods that we know and love. Love's diapers, Bounty paper towels, Cascade dishwashing soap. What you don't see on here is Procter brand anything, Gamble brand mouthwash, Gamble brand laundry detergent. Procter & Gamble is what we call a trade name. That is the name of your company that you file with the Secretary of State. And as you can see from this slide, the names of your goods and services may not be the same as your trade name. The names on your goods and services are trademarks, and we'll get a lot more into what a trademark is specifically later. But to file your company with the Secretary of State, you're going to file articles of organization, articles of incorporation, and you're going to put a trade name there. To be approved as a company name, as a trade name from the Secretary of State, all that is required is that you are one character off anything that they've already registered. So let's say my last name is McDonald and I'm a good cook and I want to form a restaurant and I want to call it McDonald's Restaurant because that's my name. So I go to the Secretary of State and you can see where I circled in red, we have McDonald's Realty and then McDonald's Restaurants of North Carolina, Inc. So I could, at the Secretary of State level, file McDonald's Restaurant, and they would let me file that, not a problem. I think it should be obvious to every single one of you that there is a federal registered trademark for McDonald's that is a franchised restaurant. And if I started offering restaurant services under McDonald's Restaurants, even though the Secretary of State said not a problem, it's a huge problem. So what you call your restaurants, kind of like the name on your birth certificate, and maybe you have nicknames and maybe you have offshoots and your products for most small businesses are offered under your trade name. So it gets really confusing in people's head, trade name, trademark. So just because the Secretary of State says it's an available name, it is for their purposes because they can tell you apart from all the other corporations or LLCs or entities that they've registered. You're going to need to go the next step and make sure that you're allowed to advertise your products and services under that name. I'm going to go into trademark law a lot, but I just wanted to make you aware that doesn't begin and end at the Secretary of State. Now we're going to talk about your intellectual property for your company. These are your ideas. That's why there's a light bulb on here. Every single business starts with an idea. And intellectual property, IP, those are your intangible assets, trade secrets, patents, trademark, copyright. It all starts with a trade secret. I have this great idea to manufacture a new kind of face mask. I have this great new dog food. You have an idea. I have a way to streamline small business accounting and invoicing and billing. That's a trade secret. There's a little bit of statutes or laws on how to protect a trade secret, but what it boils down to is how secret do you keep it? What steps do you use to keep it a secret? And I'm going to go into that in more detail. Your trade secret may also be one of the things on the next row. Patents are machines or processes. Copyrights are creative works. I think copyright is a really awkward body of law in connection with business because very few business assets fall under copyright and it's hard to protect some of them. I'll go into all of these in more detail. And then, as we said, your trademark is your brand name or logo. So those are the 4 intellectual property that you may have in your business. All right, so trade secret. What do you have? How do you protect it? What is a reasonable way to protect your idea? What do you have in your business? What's your secret sauce that gives you a competitive advantage? And if your competitors knew it, you'd lose market share because it would make you equal. How do you protect it? So I have a client that has a recipe book for recipes she uses in her business. And she just has it in a notebook and all her employees can see it. Nobody signed a non-disclosure agreement. She says, a customer could walk around the counter and look at it and take it, but I don't want to lock it in the safe because people need it during the workday and I'm not always there. So what can I do? So we talked about where she could keep that notebook, where it's not just out. Maybe it's in her office and not in the safe, or, it's in a closed cabinet. So nobody who walked in would know it. All her employees that get to make the recipes have to sign a non-disclosure agreement. It says these recipes are the property of the business. There are engineering firms that have signed and I'm not signed, numbered copies of plans, and you have to check them out and check them back in. You could put passwords on sensitive computer information, even if you have a server and your employees are all in there, you can lock files. For attorneys, we have trust accounts. There's a huge amount of fraud, people trying to get into them. Some attorneys have computers that are not connected to the internet, and that's where we keep our trust account software. And there's 1 or 2 people in the office that are allowed onto that computer, and it can't go on the network, and it's dedicated to just that. So that's what makes sense for the trust account. I don't know exactly what you're going to need in your business. I don't know what your secret is. I don't know what's reasonable to protect it. These are some things that work, and that's something, if your business is based on a trade secret, the Coca-Cola formula, allegedly it's divided in 2, and there's the 2 halves of the formula, how to make Coke, are in 2 separate safes and 2 separate locations. Because that's their whole business. What's in this product? So what makes sense for you? Questions about trade secrets? All right, if there are, I'll come back to them. So I'm going to tell you, I don't do patent law. That's a specialty. The people who do patent law are going to have science degrees and law degrees. But you think of an invention, a specific machine, something that's manufactured, an improvement of these, it's a thing or a process to make a thing. That's what a patent is. Very high level, it's a invention. Do not disclose your patent to anybody unless you have a signed confidentiality agreement, sometimes called an NDA or non-disclosure agreement, because there are certain rules about if you've disclosed your patent before you file the patent application.
Here's a quick one related to the intellectual property. It's talking about PDFs, sharing PDF files. Is a sentence put on the PDF, don't copy or distribute, is that enough, or does something else have to be done to protect that information?
It depends what's on the PDF and what's going on between the people. If you're really concerned about sharing the ideas or the exact wording on the PDF, I would have a non-disclosure agreement with the other party first and not just do not copy. So you can see patent applies to concrete physical things. So any kind of abstract idea or anything that, you can't make a model of it or say, here's the way to make this, is not subject to patent law. All right. Copyright is actually in the Constitution so that artists and authors have a period of time where they can make money from their creation. And then after that period of time, it goes into what we call the public domain so that other people can be inspired by that and build off of it. And so as you see, the list of things that are covered by copyright are really artistic. And to the extent you have a brochure or a white paper or something written in your business, that is subject to copyright. It's really made for books, but if your work is somewhat original and not just a form, you can protect it. And I know there are businesses where, you know, there are musicians and songwriters and photographers. Most businesses that aren't an artistic business, not a lot of what you use in your business is really protected by copyright law. If you have drawings or artwork commissioned for you to use, that's subject to copyright. If you have photographs, that's subject to copyright. Websites are very hard to protect by copyright. There is, if you need to know how to protect your website, the U.S. Copyright Office has a, they call them a circular. It's a fact sheet on protecting your copyright in your website. It's not straightforward because the internet wasn't invented when they wrote the Constitution, and the copyright laws have not been updated in a long time. There is this concept a lot of people know called works made for hire. And a lot of people think that because I went out and commissioned a graphic artist or a photographer or a web designer to make something for my company owns it. So if you have an employee that creates these things for you within the scope of their employment, yes, it automatically, the work gets automatically assigned to the company. But if you're hiring a contractor or third party, you go on Fiverr or Upwork or whatever, the person who created that work is the copyright owner. Unless, and if you look at that list, there's not one single thing that any business I've ever represented has. Well, maybe a motion picture, audio-visual work. But you don't go on Fiverr to get a translation or a compilation or a test. So works made for hire doesn't really apply in the business construct. So if you're hiring someone to create something for your business, you want a work made for hire contract, which says, when I'm done paying you, I own this stuff. You're going to assign it to me. That's really important. There's stuff we can do. You can get an implied license, but sometimes it gets really murky and you can't find those people. So make sure if you're having something created for your business, you get them to assign it to you.
What about with like a logo or with publicity material, marketing material that somebody else creates for your small business? How do you make sure that you actually will own that stuff now once they create it?
Work made for hire. I'm hiring you to create a logo. I'm hiring you to draft copy. As soon as I pay my final payment, you assign this to me. Okay.
But that's a previous agreement you make, or that's the standard? If you pay for it, it's done, it's mine.
Well, I draft them so that when the final bill is paid, it's transferred, because I think that's fair to the contractor. I don't think they should assign it till, the business has done what they're supposed to do.
So there needs to be an agreement, basically.
There needs to be a written agreement.
Okay.
And speaking of logos, logos are trademarks. All these things are trademarks. Trademark is pretty much anything that shows your customer who makes these goods or services. Of all the intellectual property we've talked about, trademark is different than the others. Trade secret, patent, copyright protect the assets of the company that owns them. It gives you revenue source, gives you competitive advantage. If you have a patent, you can be the only one to make this for a period of years. You have a copyright, you're the only one that can copy it, distribute it, sell it for a period of years. Trademark is actually a consumer protection statute, so that you know the qualities or the quality of the good or service you're buying. So there's like a million hamburger restaurants, fast food. There's McDonald's, Big Mac, Burger King Whopper, Wendy's Triple, Zaxby's Chicken Sandwich, Chick-fil-A Spicy Chicken. All of those mean something different to different people. And I might want to go to Zaxby's because I don't like Chick-fil-A's politics. Or I might want to go to McDonald's because they don't use peanut oil in their fryer and my kid has a peanut allergy. Or, I like Wendy's square burgers. They taste fresher to me. All of those are qualities of the product that are represented to you, the consumer, in a trademark. How do you feel about this product? So as you can see, it could be a word. It could be a stylized word, like the way Pinterest is written. If you see the Ford oval or the way Ford or Coca-Cola are written in script, those are trademarks. The shape of a Coke bottle is actually registered trademark because you can see that bottle and know what it is. Colors could be trademarks in some situations. The yarn is on there because it's scented, and that could be a trademark because it doesn't have to be scented. So the fact that there's scented yarn means it's produced by a specific company. MGM Lion's Roar is a trademark. The look and feel of TGI Fridays is a trademark. So trademark is pretty much anything that identifies your product or service to the public. I will say trademarks are super complicated. You get some rights by just using them in commerce without registering anything, and you can keep people that are confusingly similar to your name or your product name. I'm working right now with a corporate wellness company that didn't register anything, and there's a yoga studio that moved like in their neighborhood that offers yoga classes under almost exactly the same name as the wellness provided by the corporate wellness. And so we're writing them a cease and desist letter based on what we call common law, which just means I'm using it, I used it first, people are going to be confused, please stop. You can file a state registration. That gives you the exclusive rights to use your trademark in all of North Carolina, no matter where you're using it in North Carolina, actually using it. And you can get a federal trademark registration that gives you exclusive rights to use this all over the country, even if you're only using it in North Carolina. So when we talked about trade names versus trademarks, I always search the state trademark database and the federal trademark database before I form a company to make sure the name is available. And this is where, if I search McDonald's restaurant, I would have seen, there's this McDonald's corporation and they've got 300 trademarks with Mick anything. Maybe I should get a new name. If you're having trouble getting your first choice domain name, you might have a trademark issue, you might not. Trademarks are registered in connection with a specific good or service. So we can have Domino's Sugar and Domino's Pizza, and we don't get confused. There's Smithfield Farms, which produces pork, and there's Smithfield Barbecue, which is a restaurant. Those are owned by different people, but there can only be one Smithfield.com. So you might not be able to get it, and it might not be a problem because it might be something with a similar name and a very different product, but it might be a problem. And if that happens, maybe either do some trademark searching on your own or talk to an attorney. IP questions, because I'm going to switch topics when we're done with this slide.
The only question that was related to that is a DBA the same as a trademark, or how are they similar?
Okay, a DBA is when you have, all right, here's a DBA. The official name of my law firm is Berkelhammer Law PC, because the bar says I have to use my last name in my law firm name. I think that's really stuffy and stupid. So I have a DBA of legal direction. So legal direction is kind of like a nickname for my company that I go by. So if people want to be able to find me to sue me or send me legal documents, they have to be able to figure out, well, who is legal direction? How do I notify them? You file a DBA, also called a certificate of assumed name, with the Register of Deeds where your company is located. So it's when you use a different name than what you registered at the Secretary of State. Is that clear?
Yeah. And how is it similar to a trademark? Because there are aspects of it that are like a trademark, but
it doesn't matter if you have a DBA or a trade name. Those are just the name of your company. But if you also use that name as the product or the service that you're marketing to the public, then it's also a trademark.
Whether it's registered or not, correct?
Whether it's registered or not.
Okay.
And you don't have to register them. It's just really hard to tell where you're allowed to use it and what's like too close geographically and causes confusion if you're not registered. It's just kind of mushy. Like I have a yoga studio in Raleigh, and then there's somebody with a yoga studio in Fayetteville with the same name. Geographically, is that so close customers would be confused? Is it different if it's a restaurant? Is it different if it's a trucking company? It's all kind of mushy, to be honest with you, and difficult to enforce when you're not registered. All right.
Thank you for that.
I'm sorry. Is that more follow-up?
Sorry. No, I just said thank you for that. Yeah.
Okay.
We're good.
All right. So we're going to move on to limited liability and choice of entity. And I want you guys to understand what limited liability is. So this is Catherine. She has a husband and a couple of kids, and she loves to bake. And as her kids grew up and grew older and she wasn't so hands-on, she got kind of bored. And so she started baking and sending stuff into her husband's office. This is clearly a pre-COVID example. And everybody loved her food at work. They're like, you should start catering. So she did. She started a catering company out of her home, and she did custom baked goods, and she did parties, and word of mouth grew. And so she hired Danny, the delivery driver, because he could deliver some parties and set them up, and she could do others, and she doubled her business. And it was going great till Danny, the delivery driver, hit a school bus. Nobody was hurt, but they were all shaken up. And you know how parents are when their kids are involved, and they sued her. Well, remember, Catherine started this out of her home, and it just kind of grew organically. And she didn't really have business insurance, and she didn't have limitation of liability. And so the judgment came out of her own pocket because she didn't have limited liability, and they had to liquidate some of their stocks in their retirement account to pay these parents for the kids that were shaken up. If she had an entity, the money would have come out of her business. And if there wasn't enough in the business, she would have just closed the business or declared bankruptcy. So that's the importance of limited liability. How do you get limited liability? Here are all the entities that are available to you in North Carolina. Sole proprietorship is Catherine. She just started a business. This could be the kid that mows your lawn. This could be a musician that has gigs. It could be people that have, sell products out of their home, multi-level marketing. I just opened a business. I'm a sole proprietor. I put joint venture up there because some states have a joint venture statute and people ask about it. We don't have one in North Carolina. So there's no limited liability called joint venture. That just means we have an agreement to do business together here. Other states, it's different. If I'm a sole proprietor, but there's two of us, that's a partnership. General partnership is both of us working in business together to make a profit, and either one of us can sign documents, either one of us can enter contracts, agree to stuff. And if Nathaniel and I are in business and he says, hey, we're going to go provide new carpets at the airport and we can't do it, and I have more assets than him, even though I didn't do anything, they could sue me because he bound the partnership. But this is the first entity that we can form a limited liability partnership, or a limited partnership where one of us runs and manages the business. We're the general partner. And then the rest of us invest money into the partnership because we think the business is a good idea, but we're just kind of passive investors, and we have a management team and a general partner. That has limited liability. We don't see a lot of those outside of real estate, but it's there. And then there's an LLC and a corporation, which you file documents at the Secretary of State, also for a limited partnership. And you create a new person. It's a new legal person separate from you. And that's how you get limited liability. If you are a lawyer, a doctor, an architect, a CPA, there's a bunch of other professions in the statute. There's a statute called professional corporations. If your profession is listed there, and those are all licensed professionals that the state gives you a license, you have to form either a professional limited liability company or a professional corporation. Not every profession has to. You have to go and look at the statute to see if that applies to you. And that means there's an extra step when you form your company that you have to get a document from your licensing board that says you're licensed and in good standing. But otherwise, those are the same as LLC or corporation. So if you're just in business by yourself or with a partner, you've got no limited liability. If you are LLC or corporation, you do. Do you need limited liability? You might not. You might be a graphic designer that has a really good contract that says, if the client doesn't like what you do, you're going to give their money back. This is one of those, it depends. I think there are three main reasons to form an entity. One is you're in a risky business. If you are dealing with food or kids, you 100% need liability. If you're in a business where we can write you a really good form contract and get you really good insurance, maybe you don't need liability. So risk. Another reason to have an entity, even if you're not risky, is marketing. Does it help you in the marketplace to have an entity? And not just, I'm doing this by myself. Do you look more professional if you have LLC or Inc. after your company name? And the number one reason beyond risk is tax issues. Often you can save on your taxes by having an entity. That is a question for your CPA. And which entity you form is often determined by your CPA and your tax situation. If you've got a lot of people involved, you probably want an LLC because, Nathaniel or I in business, we want the entity to be stuck with our bad decisions, not us individually. The more people you have running around representing the business, the more risk you have. If you have employees, again, more risk you have. You probably want to be an entity. Sometimes the kind of financing you want to get, we're going to talk about that later, is easier to get if you have an entity. And how much expense and formality are you willing to put up with? Questions. This is like general. I'm going to get more into what is an LLC, what is a corporation next.
At this point, I don't see any questions.
Okay. All right. Limited liability company is really flexible. There is very little in the LLC Act. It is designed for people to come together and design their business, who's putting in what, who's getting out what. Super flexible, super easy to form and manage and run. You form it by filing articles of organization with the Secretary of State. It is owned by members. So most people are not familiar with this terminology. Members are like shareholders of a corporation. They're the owners. And then in North Carolina, all LLCs, the managers are the members. Managers are like the board of directors and the officers all wrapped into one. They make the strategic decisions for the company and the day-to-day operations. And it's taxed like a partnership. So what that means is the entity itself doesn't pay taxes. If it has 2 or more members, it will file a tax return but not pay any income taxes at the company level. It'll say, here's what we made and here's our ownership percentages. And then the IRS will know to look for income among the partners or the members. If you are a one-person LLC, the IRS considers you a disregarded entity. And I know that raises your blood pressure because you want an entity, because you want limitation of liability. What that means is only that the IRS is not looking for your LLC to file a tax return on its own. You can file a Schedule C on your personal income tax. Corporation, very, very structured and centralized. A lot of law, a lot of rules, not very flexible. Basically, how much money did you contribute? That's how much you owe. The corporation itself files a tax return and pays income taxes. And then if you are an owner and you've got a dividend, because remember, you buy shares in a corporation because you're going to make money, they're going to pay you a dividend. Same for yours. After your expenses, you can give dividends to the owners as return on investment. You pay taxes on that money again, and it's double taxation. If you just form a corporation and just pay taxes, you're called a C corporation because it's Section C of that part of the Internal Revenue Law, the Internal Revenue Code. You can elect to be taxed under the S section instead of the C section. And what that means is you're going to be taxed like a partnership or an LLC, where the corporation files an informational tax return. And even if you're a one-person S Corp, you still have to file that tax return. You're not a disregarded entity. And then you pay all the taxes at your individual level on your individual tax return. How do you decide LLC or corporation? Number one distinction is tax. And that's where a CPA can look at your overall financial picture. Sometimes there's really stark differences between the LLC format and the corporation format, and it's a clear picture. Generally, there's not, though, especially for a startup. I will show you on the next slide why I think LLCs are much easier small business formats. So if there's no compelling tax reason, I say go LLC. Also, remember, corporations are very structured. They're very formal. If that's not your gig, go LLC. But if you're not a U.S. citizen or you don't have a green card, you cannot be an S corporation shareholder. So sometimes that pushes us to LLC because of immigration status. I don't know why that is. It just is. All right. To get your limited liability, you need to be properly formed, properly capitalized, properly run. Properly formed means you filed your articles of organization, you have an EIN, you have a bank account. I'm going to show you another slide in a minute. Properly capitalized I've never had in real life a company that wasn't properly capitalized. But in law school, we read this case where there was a company in New York City that had a lot of taxi cabs, and they put 3 or 4 taxis in an LLC that was owned by a big corporation, so that if a cab got into a wreck, there was only 3 or 4 cabs as assets to go after. On purpose, so that like you didn't have the insurance for the whole company, you didn't have the assets of the whole company, you didn't have the revenues of the whole company. Like, these 300 LLCs with 2 taxi cabs each. The court found that to be fraudulent capitalization because the risks weren't properly identified when they started up. I've never seen that in real life. You can shoestring, you can bootstrap, not an issue. And you have to be properly run. So you've got to file your annual reports with the Secretary of State, and whenever your taxes are due. For corporations, it's going to be due March 15th. For LLCs, it's going to be April 15th. But and I'm going to send you these slides. Mostly I want you to see how empty this one is. Not a lot to do to form the LLC. Look at all the things you got to do to form your corporation. A lot of people, and there's a typo on that slide. A lot of people file their articles, get their EIN, and they're done. They don't issue shares. They don't have organizational meetings. They don't have their annual meetings going forward. That puts a crack in your limited liability. Final thing I want to tell you is you see these, I don't even know what they are. They're locking horns. If you have more than one owner, I'll get to questions in a sec. If you have more than one owner and you don't agree and somebody wants to get out of the corporation or the LLC, there's very little in the law, in the statutes, in the case law that will help one owner force another owner out of the company. So, did one owner contribute their idea, their trademark, their website? Did one owner do all the videos that on the website and wants his image back? What happens if somebody dies? What happens if you don't agree on the direction of the company? If you don't have a written agreement, it'll be a shareholders agreement, might be called a buy-sell agreement. It's part of the operating agreement of the LLC. If you haven't put these in place ahead of time, basically all you can do is petition a judge to dissolve your entity and decide what happens to your assets, and it's horrific. So if there's more than one of you, have an agreement up front. Okay, questions?
So the question in the chat is, are you required to file a separate tax report for the Escort business and then one for your personal tax to include your income from the business?
Yes, you file a 1140S tax return for the Escort, and then you have a K1 on your personal tax return that says how much money you made that you need to pay taxes on. You pay it as an individual.
If anybody has any questions on this, please put them in the chat. I do want to ask this real quick. It's just kind of mention a situation that we deal with a lot is people get counseling to open a corporation instead of an LLC because of some tax reason that they're not specifying. And the person does exactly what you said. They file the corporation, they get an EIN, and then they're out, right? That's all they did. So what is a good step? Can they do the next steps on their own? Should they seek help? Do they need more people involved? What is kind of the next step for those people to be covered?
Yeah, I'm sure there are online tutorials on what goes into, you've got to have the shareholders have to elect the directors. The directors have to elect the officers. I have like a 6-page organizational meeting minutes where we adopt the bylaws, we issue shares, we name the bank, we hire professionals, we make some tax elections. I imagine that can be found online. There's probably some self-help places that have all of these. I think, any of the any business lawyer will do that as part of forming you. That's you pay for that service. LegalZoom will do it. I'm not a big fan of their agreements, but at least you have something. And I know there are like Nolo.com, NOLO has a lot of self-help resources that are pretty good if you want to do it on your own. But corporations are a little tricky, and there's a lot of steps that people don't realize.
Is there any benefit in a person saying, wow, I didn't realize that. Let me dissolve this and open an LLC instead, or can it transfer it back or something like that?
You can file articles of conversion, which convert the LLC to an S Corp or the S Corp to an LLC.
Okay.
Actually, any entity to any entity, but and that's fairly straightforward.
Awesome. Thank you for that.
Yep. All right. So what else? I'm sorry, I had one more. I forgot. Ownership agreements, register with the Department of Revenue. I don't know what you need, and they won't talk to me. That's either you or your accountant. You might need a payroll account. You might need sales and use account. There's different ones. We're going to talk about insurance. Yeah, just make sure you have good commercial insurance that's based on what your specific company does. Insurance and form contracts, which I'm going to go into in a minute, are like the two cheapest, best things you can do to protect your business with or without an entity. So I overinsure, like I buy every kind of insurance to what I think is a decent level, just because it's cheap compared to lots of other ways to protect yourself. All right, I'm going to gloss over financing because I'm running a little long today. There's two kinds of financing for your business. Debt is where you get a loan, whether it's from a bank or for friends and family. Equity is where you sell ownership in your company to another person. Don't give up equity in your company unless you have to. It's really hard to get it back. You are stuck with this person as a partner in your business, until we get them out. And if you don't have an agreement on how to get them out, it's rough. A lot of people don't understand, like, oh, I'm starting up and my friend Joe is going to give me some money, so I'm going to make him a 20% owner. Sometimes Joe disappears and we can't find Joe, and he can't sign documents when you want to sell the company or get a loan, or I'm just going to put that issue there. If you're going to have multiple owners, definitely get a lawyer and have the proper agreements in place. If you're borrowing money from friends and family, get a formal promissory note, document it, make sure it's on your books, because when you go to get financing from a bank later, they're going to want to see you did that properly. Make sure your ducks are in a row to get your financing, have your business plan, do your homework, have a good case. I'm going to skip this because I want to talk about contract law. Yeah, sorry. All right. Yes, verbal agreements are enforceable and legal, but they're bad because they're hard to prove what you agreed to. And sometimes there are very legitimate differences of opinion where it turns out you guys never agreed on what was the business transaction, what was the price, what was delivered, how much. And it is so hard to prove what the agreement was and who owes what if there's no documentation. It's, well, I remember it this way, I remember it that way. Okay, I don't know what to do for you guys. So even if you just send an email saying, great talking to you today, here's an email to summarize what we agreed to, that might be enough writing. Leases, anything to do with land has to be in writing. Contracts that take more than a year to complete, like some kind of long-term project, have to be in writing. This is really old. Sale of goods over $500 have to be in writing. That was a lot of money when the statute was written. It's not so much now. Or if you're going to guarantee, like a personal guarantee for your company, that has to be in writing. Valid contract has to have what we call consideration. You have to have offer and acceptance, and you have to have definitive terms. Offer and acceptance is usually, I want to hire you to create a logo and you're going to charge me $50. We've offered, we've agreed, we have consideration. There's a mutual exchange. Sometimes though, somebody says, here's a form contract. Here's my first draft at it. Here's the services and the price for, I'm going to design your website and your logo and your graphics and all your collateral. And instead of signing it, the other person says, well, wait a minute, I need the deliverables 6 weeks prior, and I don't want to pay for the website. I'll get that on my own. That's not acceptance. That's a counteroffer. And sometimes there's such fierce negotiating for a deal that it's hard to tell exactly what the contract was. For most small businesses, this is not an issue. Just saying you have to have offer and acceptance. And then usually the consideration is, I'm going to sell you X and you're going to pay Y. Sometimes the consideration is that you're not going to do something, which is like a non-compete. I'm going to give you this job and you're going to agree, I'm going to give you a $500 bonus and you're going to agree not to compete with the company for 5 years. So offer and acceptance, mutuality, definitive terms. At a minimum, correct names of the parties and the person who's enabled to sign for it. I can't tell you how often I see contracts where the name of the business is wrong. It's Joe Smith, president, but it's an LLC and they're really a manager. Get those details right. You have to have the consideration in there. We have to be able to tell in the contract that there was valid consideration. And again, most of the time it's going to be, I'm going to buy X, you're going to pay Y. Super easy. Price and payment terms, or a method of figuring out what the price is. If you don't have a price in your contract, the court is not going to come in and figure out what you agreed to pay. Almost every other thing that you leave out of your contract, we have something called the Uniform Commercial Code, the UCC, which is a gap filler. It'll figure out delivery. It'll figure out, if the truck got in an accident on the highway, whose insurance is going to pay to, for that damages. We can't figure out what you wanted to pay, and we can't figure out how you're going to pay it. Is it milestones? Is it lump sum? Is it on invoice? It will not be a valid contract if you don't have the price and payment terms. It has to be signed. Somehow you guys have to indicate you agreed to be bound by the contract. Or in some cases, you can start performing it, and that counts as acceptance. But those are the bare minimum things you need to have in your contract. What are good things to have in your contract? Especially if you're doing something custom, which is usually services or a good you're manufacturing for someone, really clear definition of what you need to do. And I know we're at 1 o'clock and I'm sorry I ran late today. I got excited at the beginning. So if you need to drop off, please do. It won't hurt my feelings and we'll get you the rest of the slides. If you're offering services, really, really important to state what those services are and when they're done. Imagine you're a graphic designer and you've gone through the whole creative process with the client and you talk to them and what's the company about? What colors do they want? What kind of graphics do they want? Here's my 3 mock-up logos for you. Pick one. Okay. I'm going to create your website now. I'm going to create all your collateral and your flyers and your email signature. Here you are. Pay me the rest of the money you owe me. You don't like it? Wait, I need to redo it again? No, but we have a contract doesn't say like I'm done if you rejected it the last minute. I've had that happen. It's horrible. So what goods are you providing? What specifications? What services are you providing? What happens if they don't like it? That needs just be super clear on that. Those are business terms. You can do that on your own. You can review those on your own. Price and payment terms. If there's going to be penalties for late payment, has to be in your contract. Delivery terms. Are you sending it by truck? Are you going to email it? Do they come pick it up? Do you have a delivery driver? Risk of loss. If the truck slides on the ice or gets, hit by a hurricane, whose insurance is going to pay? When does that start? Warranty. I warrant that the product will be delivered to you according to your specifications with no manufacturing defects. If there is a defect, here's the process. I warrant these services are good and workmanlike in accordance with local standards. If you don't like it, I will reperform it once or I will discount your contract. You want to have those kinds of provisions in there. Indemnification is where one person makes a mistake. Suppose I'm a software developer and I copy someone else's software and I sell it to you, and you get sued for copyright infringement. You're going to come to me and say, hey, dude, what the heck? You need to pay my legal fees for this. You need to get me software license for their stuff. You need to work it out. I'm not paying a penny because you screwed up. You're going to indemnify me for what you did wrong. As you can imagine, a lot of money hides in indemnification provisions, and you should look to see if they're mutual, if they're one-sided. I review an awful lot of risk of loss, warranty, indemnification on contracts for people that understand the business terms but don't understand these legalese boilerplate. Lots of money hides there. You have to ask for attorney's fees in the contract if you have to sue someone to enforce the contract. Even when they're there, the courts don't like to enforce that provision, but if they're not there, they can't. So look to see if you owe attorney's fees if they have to sue you, kind of thing. Dispute resolution, there's 3 different kinds we have. We have, you go to court, somebody files a lawsuit. We have mediation, which is where somebody comes and talks to both of us. We both say what is wrong, what we want out of it, where the contract went bad, how to make it better. And then we go into separate rooms and the mediator goes back and forth and tries to get us to agree to a resolution. If we don't agree, then we're back at court. And then arbitration is kind of like court light. We agree to pick an arbitrator who is going to be in a quasi-legal setting. The rules of evidence don't apply like they would in court. There's limited ability to ask for documents, to have depositions or subpoenas. So both sides will present their evidence and the arbitrator will ask them questions and make a decision. It could be binding or not binding. If it's binding, that's the decision. You're stuck with it. There's no appeal process. If it's non-binding, you go back to court. Arbitration was designed to be faster and cheaper than going to court, but it doesn't always work out that way. None of these are good or bad. I just wanted you to be aware of what they are. Questions?
I don't see any questions at this time.
Okay. And then the last issue I want you guys to understand is that it is not your decision as a business owner when you need help if it's an employee or a contractor. There is a huge body of law between the IRS and the Department of Labor that if the more control you have over that worker, what they do, where they do it, how they do it, the more likely they are to be an employee. So if you hire someone, said, here's your workstation, here's your uniform, here's our flow chart, this is exactly how you're going to do your work. Doesn't matter if they're part-time, they're your employee because you have a lot of control over what they do, and they're entitled to workplace benefits as an employee. If it's more like, oh, you have your own LLC, you're doing this kind of work for lots of different people, and I'm going to hire you to do a project, and I'm going to give you 6 weeks, and I'm going to pay you $300, and at the end of that time, you deliver my work to me. That's a contractor. Those were really stark examples, and sometimes what you have offered somebody is murky and it's in the middle. Seek help there, because the penalties, if you misclassify someone, are horrible. You're going to pay all the back taxes you didn't pay on your employee because you thought they were a contractor, doubled, because there's a 100% fine. Then they're going to come in and do an audit of all your workers and make sure they're properly classified. I had a client that came in last week that was hiring someone as artistic director of a production company, and they were vetting talent. They were setting up shoots. They were marketing. They had a 5-year contract for an independent contractor, but it was part-time, and they were getting paid, a flat rate for 20 hours, they were getting paid $2,000 a week. But if they worked more, they could get paid. I'm like, guys, that is a contractor. Let's make it project by project, and let's not do the real high level. Let's hire people. Let's vet new vendors. Or form an LLC for the contractor and do this for a lot of people. So just know that it is not your choice. We need to figure out what they're doing and how they're doing it. You can't just hire them as a contractor to save yourself the taxes. All right. Speed lesson. And I'm so sorry I got off track at the beginning.
I'll share the recording if that's all right with you, Donna.
Absolutely.
As well. Okay. You're done. No, sorry. I was expecting you to say something else. Thank you so much. I enjoyed this a lot. There's a lot of stuff in here that I had not put too much mind into. Lots of questions that pop up that people ask. That there's good information here, and I appreciate you being with us. Everybody else who was here, thank you so much. I hope we got your questions answered or sparked some more questions. If you have more questions, definitely check out Donna. I'm going to put your contact info in the email as well, Donna, that I'll share with everybody. Visit her or visit us, and we will send you to her or to somebody else if it's a legal question. We definitely don't offer legal advice, but we do want to guide you in that direction. It's been a pleasure to have you, Donna, and everybody else here. Thank you so much, and have a great rest of your day.
Thank you.